Yes, ma'am.
Mr. Fitzgerald, your critics are charging that you are a partisan who is conducting what, in essence, is a political. Well, you tell us.
You tell me.
Conducting a political witch hunt. I mean, how do you respond to the? Since you are in Washington, it seems.
Okay. I don't know. Sort of when you stop beating your wife. I've read one day I read that I was a Republican hack. Another day I read I was a Democratic hack, and the only thing I did between those 2 nights was sleep. I'm not partisan. I'm not registered as part of a party, and I'll leave it there.
You noted earlier that the grand jury's term expired, but you said something about holding it open, or will you be working with a new grand jury?
The grand jury, by its terms, can serve, was an 18-month grand jury. By its statute, to my understanding, can only be extended 6 months. That 6 months expired. It's routine in long investigations that you would have available a new grand jury if you needed to go back to them. And that's nothing unusual. I don't want to raise any expectations by that. That's an ordinary practice. Yes, sir.
I think you've kind of answered this, but I assume that you have no plans and don't even think you'd be allowed to issue a final report of any sort.
You're correct. But let me explain that. I think what people may be confused about is that reports used to be issued by independent counsels. And one of the complaints about the independent counsel statute was that an ordinary citizen, when investigated, they're charged with a crime or they're not. They're not charged with a crime. People don't talk about it. Because of the interest in making sure that, there was an interest in independent counsels to making sure those investigations were done thoroughly. But then people ended up issuing reports for people not charged. And one of the criticisms leveled was that you should not issue reports about people who are not charged with a crime. That statute lapsed. I'm not an independent counsel, and I do not have the authority to write a report. And frankly, I don't think I should have that authority. I think we should conduct this like any other criminal investigation. Charge someone or be quiet. Yes, sir.
Isn't it true that Mr. Comey's letter to you makes you, in essence, almost the de facto Attorney General, and you can abide or not abide by the CFRs or the regulations as to whether or not to write a report or not to write a report? And the follow-up is every special counsel prior to you has, in fact, written a report and turned it over to Congress. And they've gotten around the grand jury issue as well.
Let me say this. I think any prior special counsel may have been special counsel appointed to certain regulations for people outside the Department of Justice, which I do not fit into. I'm not an independent counsel. I may be unique in this sense. I can tell you I'm very comfortable, very clear that I do not have that authority. And to the extent that I was given sort of the acting Attorney General hat for this case, it's the acting Attorney General, but the Attorney General can't violate the law. And the law on grand jury secrecy is the law. So I may have a lot of power for this one case as acting Attorney General hat, but I followed the Code of Federal Regulations in this case, and I certainly would follow the law. Yes, ma'am.
Mr. Fitzgerald, the Republicans previewed some talking points in anticipation of your indictment, and they said that if you didn't indict on the underlying crimes and you indicted on things exactly like you did indict, false statements, perjury, obstruction, these were quote-unquote technicalities, and that it really was overreaching and excessive. And since when and if they make those claims now that you have indicted, you won't respond, I want to give you an opportunity now to respond to that allegation, which they may make. It seems like that's the road they're going down.
And I don't know who provided those talking points, I assume. I'm not asking. Okay.
In anticipation of your...
I'll be blunt. That talking point won't fly. If you're doing a national security investigation, if you're trying to find out who compromised the identity of a CIA officer, and you go before a grand jury, and if the charges are proven, remember there's a presumption of innocence, but if it is proven that the chief of staff to the vice president went before a federal grand jury and lied under oath repeatedly and fabricated a story about how he learned this information, how he passed it on, and we prove obstruction of justice, perjury, and false statements to the FBI, that is a very, very serious matter. And I'd say this. I think people might not understand this. We, as prosecutors and FBI agents, have to deal with false statements, obstruction of justice, and perjury all the time. The Department of Justice charges those statutes all the time. When I was in New York working as a prosecutor, we brought those cases because we realized that the truth is the engine of our judicial system. And if you compromise the truth, the whole process is lost. In Philadelphia, where Jack works, they prosecute false statements and obstruction of justice. When I got to Chicago, I knew the people before me had prosecuted false statements, obstruction, and perjury cases. And we do it all the time. And if a truck driver pays a bribe or someone else does something where they go to a grand jury afterward and lie about it, they get indicted all the time. Any notion that anyone might have that there's a different standard for a high official, that this is somehow singling out obstruction of justice or perjury, is upside down. If these facts are true, if we were to walk away from this and not charge obstruction of justice as perjury, we might as well just hand in our jobs. Because our jobs in the criminal justice system is to make sure people tell us the truth. And when it's a high-level official in a very sensitive investigation, it is a very, very serious matter that no one should take lightly.
So, this doesn't relate to the charges, so I'm hoping maybe you can shed some light on this. But in your investigation, have you determined how it was that Ambassador Wilson became the person to be sent to Niger to investigate the situation? How directly involved was his wife in this election? How much pressure she may have put on officials? And also, I'm wondering about the cooperation you received from the CIA.
And I think all government agencies that we have turned to for cooperation have cooperated. I'm not going to comment on the circumstances of the trip. I think the only thing that's relevant, frankly, is the belief in the mind of some people that she was involved in the trip or responsible for sending the trip. The dispute as to whether in fact she was is irrelevant to the charge before us. What we're talking about is why the investigation was why someone compromised our identity, and the issue in this indictment is whether or not Mr. Libby knowingly, intentionally lied about the facts. And whatever happened in that trip and what role, if any, the wife played is really irrelevant and not our focus. What is set forth is a belief on his part that she played a role in the trip, and that is set forth in the indictment. Whether that belief is 100% true, 100% false, or a mixture of both is sort of irrelevant, but it does set forth in there that he had that belief that she was involved in the trip. Yes, sir.
Are you at all concerned that Mr. Libby or his counsel sought to affect or discourage the testimony of Judy Miller by withholding a so-called personal waiver, allowing her to testify notwithstanding a pledge of confidentiality, or through his letter to her that she reportedly received when she was in jail?
And I'm not going to comment on anything that's not in the indictment, but I can tell you that we're not relying upon anything other than the indictment, which the obstruction of justice charges set forth the statements by Mr. Libby to the FBI and the testimony under oath to the grand jury as being the basis of the obstruction charge and nothing else. Yes, sir. Yes, sir.
Thank you. The indictment describes Louis Libby giving classified information concerning the identity of a CIA agent to some individuals who are not eligible to receive that information. Can you explain why that does not, in and of itself, constitute a crime?
That's a good question, and I think knowing that he gave the information to someone who was outside the government not entitled to receive it, and knowing that the information was classified is not enough. You need to know at the time that he transmitted the information, he appreciated that it was classified information, that he knew it or acted in certain statutes with recklessness. And that is sort of what gets back to my point. In trying to figure that out, you need to know what the truth is. So our allegation is in trying to drill down and find out exactly what we got here, if we receive false information, that process is frustrated. But at the end of the day, I think I want to say one more thing, which is when you do a criminal case, if you find a violation, it doesn't really, in the end, matter what statute you use if you vindicate the interest. If Mr. Libby is proven to have done what we've alleged, convicting him of obstruction of justice, perjury, and false statements, very serious felonies, will vindicate the interest of the public in making sure he's held accountable. It's not as if you say, well, this person was convicted, but under the wrong statute. I think, but I will say this: the whole point here is that we're going to make fine distinctions and make sure that before we charge someone with a knowing, intentional crime, we want to focus on why they did it, what they knew, and what they appreciated. We need to know the truth about what they said and what they knew. Carol.
You don't feel that you know the truth about whether he intentionally did this and he knew and appreciated it? Or does that mean you're exercising your prosecutorial discretion and being conservative?
Well, I don't want to, look, a person is charged with a crime, they're presumed innocent, and I haven't charged with any other crime. And all I'm saying is the harm in the obstruction crime is it shields us from knowing the full truth. I won't go beyond that.